court.
Okay, any objection to that?
No objection to that, and I think 4 or 5 of the exhibits that have been marked are from that, but no objection to judicial notice of the pleadings in the.
What was the previous cause number again? DC what?
15-06688.
Okay. All righty. Are we ready for opening statements?
Yes, Your Honor.
And finally, one other comment, John,
Sure.
you had a amended petition. You had a motion for leave, which I believe added the Texas theft liability. I don't have opposition on that.
Oh, thank you. So we would move. We had previously asserted a claim for conversion, which has the same elements as Texas Theft Act, and so we had filed a amendment and motion for leave on the Texas Theft Act, and we have no opposition from Scott Hayes on that amendment. So we would move to have that order granted, and we'll submit a proposed order.
And that's unopposed, so that will be granted. And go ahead and email a copy of that order to Rhonda, and then say at the beginning of the order, please say on May 18, 2021, the court came on to be considered, as opposed to say on this date.
Got it.
So that it makes it clear when this was done. And go ahead and email Rhonda that as well as e-file it.
Thank you, Your Honor.
All right, any other pretrial matters we need to take care of before we start opening statements?
I think that's it.
Nothing else, Your Honor.
Okay, Mr. Palter, you may begin.
Is it possible to allow Mr. Eister to share his screen?
I'm sorry, it is already allowed.
Okay. May it please the court. My name is John Palter, and I, along with Greg Eister, represent the what are now the third-party plaintiffs, Convergence Aviation Inc. and Convergence Aviation Limited. Next slide. Your Honor, this cause of action seeks to recover damages from Orville Yarger individually in Mr. Yarger's capacity as a former director of Convergence Aviation Limited for his failure to return and release yellow tags and to release the engine and the parts which were previously determined by this court to be owned by CAL under that certain aircraft purchase agreement dated August 8th of 2008. We are seeking 2 alternative theories. One theory is a breach of fiduciary duty. That is that we actually paid to Mr. Yarger in his capacity as a director $535,000 to repair the engine and the parts. And those parts now are in his possession, and we do not have access to them. We are seeking to recover for breach of fiduciary duty amounts that we incurred plus storage fees in a total amount of $579,217. In the alternative, Your Honor, we are seeking damages associated with the value of the parts which are currently in Mr. Yarger's possession, for which we paid him in his capacity as a director, the value of those plus attorney's fees pursuant to the Texas Theft Act. As this court may remember, this case, the 16 case, is the second case which involves the construction and the terms of that certain aircraft asset purchase agreement. The first judgment, that 15 case, resulted in a final judgment awarding the engine and the parts to CAL. And for the court's benefit, Convergence Aviation Limited is a UK company. It was going to be the beneficial owner of this airplane. It needed an agent in the United States, and Convergence Aviation Inc. is the agent that held that airplane title beneficially on behalf of Cal. So I'm going to be referring to them as Cal collectively because there is an agency relationship between Convergence Aviation, Inc. and Convergence Aviation Limited. Your Honor, under the Texas Theft Act and convergence case, as is the law, upon a finding of damages, title to the engine and title to the parts would then be released to Mr. Yarger. Next slide, please. Your Honor, the summary of this dispute is that this arises out of a crash back in 2008 of an airplane which was a Mirage jet prop. The crash occurred outside of Bowling Green, Kentucky, and Mr. Yarger, who was the director of Cal, was the pilot. As part of the litigation in that matter, the aircraft hull, but not the engine or the parts, were sold to Onala. Onala is a single member entity which is owned by Yarger solely for purposes of holding that hull. As a result of the discussion in the lawsuit, it became apparent that Mr. Yarger was not using the proceeds from the insurance for the benefit of the engine and the parts, and he was terminated in his capacity as a director. In 2015, Cal and CAI made demand upon Yarger and Onala to purchase these parts and this engine or to return them. Instead of returning them, he filed the first lawsuit on June 11, 2015. After a motion for summary judgment on May 16th of 2016, Cal and CAI secured a final judgment which awarded it the engine and the parts. At that point in time, Onala had the hull and Cal and CAI had the engine and the parts. That should have been the end of this case, Your Honor. There should have been no reason why we could not have sold those parts, sold the engine, and be done. Yet that's not what happened. And that's not why we're here today. Subsequent to that, literally 20 days later, Onala files a second cause of action, not originally in this court, but it was converted to this court, and it was seeking damages under the aircraft asset purchase agreement as well as possession of the engine. Mr. Hayes did not notify this office that this lawsuit had been pending. He did not serve process on that at the last known address. So Cal was completely unaware that there was a lawsuit pending against it seeking to reverse the previous order awarding it possession of the engine and the aircraft, or the engine and the engine parts. In fact, on July 16th of 2018, Onala secured a default judgment awarding it title to the engine as well as damages. Thereafter, it went to Prime Turbine, which is where the engine was located, and said, look, we now own the aircraft, we own the engine, we want you to release it to us. And that was the first time that Cal became aware of the fact that subsequent to this original judgment, Onala was again claiming anew the title to this aircraft. Cal and CAI filed a petition for equitable review. That equitable review was granted by this court, and the final default judgment was vacated. Several months later, we filed a third-party cause of action against Yarger. And the purpose of that was that Mr. Yarger still is retaining possession over the engine and the parts, and we are now seeking damages from him in his capacity as a former director for breach of fiduciary duty and seeking damages against him for conversion of the engine and the parts. On March 30th, 2001, this court granted summary judgment, again, based upon res judicata, awarding the engine and the parts to Cal. The order specifically reserved the claims against Yarger. So to be clear, we are not seeking any damages against Onala. The only damages that we're seeking is against Mr. Yarger individually. Next slide, please. So as a result of this, Onala owns the hull of this airplane, and Yarger, because he has asserted his ownership by virtue of the second default judgment, has converted the engine and the parts. What we're seeking, Your Honor, in the simplest terms, is that we want damages for the engines and the parts, which are located in Prime Turbine here in Dallas, that they won't release them to us because of this pending lawsuit. And we want damages for the new propeller, the landing gear actuator, and the related parts that are in Yarger's hangar in Bowling Green. The evidence is going to demonstrate that Mr. Yarger was paid over $535,000 for these parts, and yet he has failed to release those parts to us. So what we're seeking is a very practical remedy. Go back one more. The practical remedy, Your Honor, is that this court should award Cal its damages, its economic damages for Yarger's conversion of the engine and the engine parts. And then upon the award of those damages for theft, the title in the engine and the title in the parts should go to Mr. Yarger. And that way, there is no dispute in the future that we've tied up all the loose ends, that Mr. Yarger now owns the hull, the engine, and the parts. And he can then reassemble this airplane, which according to his testimony, before this crash was worth $1.25 million. That's the summary of the dispute. Your Honor, we anticipate that there is an issue on the statute of limitations. I'd like to just address that very quickly.
Okay.
As mentioned, Your Honor, this case should have been resolved by the May 16th, 2016 judgment in the 2015 case. We had a judgment saying that we own the engine. We could have sold the engine back then at that time. We could have sold the parts. We would have mitigated our loss, and yet instead of asserting our rights to that engine and parts, and unbeknownst to us, they file a new cause of action seeking ownership of the engine and the parts. We weren't notified, and as discussed, they secured a default judgment in 2018. We filed a bill of review, and the equitable bill of review was granted. There are two different bases upon which we assert that the statute of limitations does not apply to the conversion claim and the breach of fiduciary duty claim. First is that because they secured this second default judgment on July 16, 2018, our cause of action for conversion could not have accrued until they secured the default judgment. We didn't know that they were now asserting a new cause of action despite our earlier judgment against them, and therefore the cause of action for conversion and breach of fiduciary duty did not accrue until July 16th of 2018. The petition for equitable review was filed on April 20th, 2020. Second, Your Honor, the discovery rule tolls claims during the pendency of the second action. I cite to the court this Wells Fargo decision. It's out of Judge Moyer's court. And it specifically stated that the discovery rule does apply to these category of cases in which a lease, while it was originally given to the defendant properly, because he is transferring it to a third party but continues to conceal his activities, that type of activity involves both inherently undiscoverable and yet objectively verifiable standard, and therefore the discovery rule applies. For those reasons, we assert that this case should not be barred by limitation. Next slide. All right, so just briefly, Your Honor, I'm going to go through the chronology. Back in 2003, Cal and specifically CAI acquired this Malibu jet. They paid about $1,400,000 to acquire the aircraft in anticipation of successful business venture. On January 8th of 2008, while Mr. Yarger was at the helm, the aircraft suffered a catastrophic in-flight engine failure at 28,000 feet, which resulted in a forced landing about 1,000 feet short of the runway in Bowling Green Airport in Kentucky. Now, the crash itself is not relevant to the claim for conversion, but for context, Your Honor, the crash, while it was originally thought to be the result of a defective Pratt & Whitney engine, it was in fact alleged by Pratt & Whitney that it was due to the fact that Mr. Yarger's son was in the left-hand cockpit flying the airplane outside the altitude ceiling restrictions of 27,000 in an over temperature condition for an extended period of time. Regardless of that, the airplane did result in the accident and an insurance claim was filed. Next slide. As part of that, the parties entered into the aircraft sales agreement, which formed the basis for the first summary judgment in the case and formed the basis for the second summary judgment in the case. The aircraft purchase and sales agreement conveys the hull to Onalla, and that was to establish the value of the hull for the damage claim. And while Yarger was a director with CAL, the aircraft purchase agreement makes it very clear that it excluded the engine and it was sold without the benefits of the parts held for repair. In his deposition, Yarger confirmed that Onalla was purchasing the aircraft hull only, but not the engine. This is his deposition testimony taken in the underlying action when they were seeking damages relating to the aircraft failure. Slide, please. Under the purchase and sale agreement, the sale excluded the engine itself, the engine accessories, the propeller, the engine mount, cowling, air intake scoop, nose gear actuator, undercarriage, and then the avionics. This is just right out of the four corners of the purchase and sale agreement. This was not sold. Next slide. Now, while Mr. Yarger was a director and he was responsible for paying for these repairs, the evidence is going to demonstrate that he received, in his capacity as a director, $535,000 to repair the engine and the parts. This money was deposited into his personal bank account under his Social Security number, and the bank account was then retitled in the name of Convergence. In exchange, what Mr. Yarger agreed to do through Onalla was to pay all the invoices associated with the airplane, including work order 825. And he was to pay them on behalf of Cal's behalf, without any further compensation or any other debts. Next slide. With that money, the parties, Cal and Mr. Yarger, then proceeded to pay for certain parts. They paid $93,000 for the propeller, which is currently located in a hangar in Bowling Green, which is controlled by Mr. Yarger, which we have not been able to get access to. They paid $35,000 for a nose gear actuator, which is also located in a hangar controlled by Mr. Yarger, for which we have not been able to get control of. They paid $62,000 for parts, which is located here in Prime Turbine, for which Mr. Yarger has not only not released them, but failed to get yellow tags, which are necessary to put the parts back in service. And then incurred $49,000 for parts which are either located in Bowling Green or in Jet Prop in Spokane. And finally, there are additional parts of $145,000 which are located in Bowling Green pursuant to Work Order 825. So the parts that Mr. Yarger was paid to incur are now in his possession, and he was paid for in his capacity as a director. Next slide. So in January of 2014, he was terminated from the board for cause. That he was not, it was determined that perhaps he was responsible for the loss of the airplane. And in fact, it was the allegation that he wasn't using the money for the benefit of the engine. On May 18th, 2015, Mr. Lentz, who was the attorney for Cal, makes a demand upon Yarger to either buy the engine and the parts or to release it. One of the two. And basically says, if we don't have an agreement by you to buy these parts, then we ask you that you return them. And alternatively, we can then sell them and recover our loss. Instead, next slide, he filed the first lawsuit. So the first lawsuit was responded on June 11th of 2015. And as discussed, after a motion for summary judgment, Cal and CAI were awarded the engine and the parts. And they found that they were the owner of the engine and that had no rights or interest in the engine. And as discussed, that should have been the end of this case. Next slide. Instead, on May 31st, Onala files a second action, which is this current cause of action, fails to notify us.
Mr. Poulter, you've already covered all this.
Okay, next slide.
Let's go to the next slide.
Yep. The documents will demonstrate that he is and was the director during this time frame. Next slide. The breach of fiduciary duty is basically that he received the sum of $535 in his capacity to repair the engine and the parts. He held it as a fiduciary. He breached the fiduciary duty by securing the yellow tags, by returning the parts, refusing to release the engine. That's the damage model that we're seeking. Next slide. Under the Texas Conversion Act, he specifically, with regard to his location in Bowling Green, has certain parts that we've paid, and despite demand, he's failed to return them, and therefore we've sustained a loss. And as discussed, upon a successful suit for conversion, the judgment must also provide that the ownership of the property is to vest in the defendant. And so what we would request is, upon a finding of our damages, that Mr. Yarger be vested in the title of the engine and the parts. Next slide. And then lastly, that we seek our reasonable attorney's fees associated with the Theft Act. Thank you, Your Honor.
All right. Let's stop sharing. Okay, do the defendants wish to make an opening statement? And can you email that PowerPoint to Rhonda, so that, and Rhonda, if you can email that to me. All right, Mr. Hayes, you're muted.
Okay. Yes. Just a brief statement, if the court will indulge. Madeline Hayes is going to speak on the issue just briefly on the statute of limitations. But as the court saw from the slides and will see from the exhibits in this case, there was a demand for return of the aircraft parts on May 18, 2015. There's a 2-year statute for conversion. The court has also seen, as Mr. Poulter set out, that he was removed, Mr. Yarger, as a director in 2014, even with a 4-year fiduciary duty statute of limitations. The claims against Mr. Yarger were brought on October 1, 2020. Mr. Yarger was not part of the previous suit. He was not part of this suit until there was a third-party claim filed October 1, 2020. So we think right there that all of the claims, and again, the recently added Theft Act is just a conversion claim, which then goes back to, which they acknowledge in 2015 when a demand was made and conversion law would say when demand is made, that's when the claim accrues. Again, it's important, even though there are other claims.
Mr. Hayes, I thought you were going to let Ms. Hayes argue the
Yeah, I am, Your Honor.
limitations.
I am.
You can't. I'm just giving you a hard time.
Okay, I'm sorry. The second point that I have, and I think we prevail across the board on all their claims on the statute of limitations, but I'm a little bit unclear from Mr. Palter. At this point, he appeared to just talk about the claims against Mr. Yarger. If he's not proceeding on the claims against Anola, then my res judicata argument at this point is moot. But in any event, if he's still making claims against Anola, there was the previous case where, in fact, the convergence entities asserted a counterclaim and attached the very exhibit 1 that's now being used today. They've also said the court had entered an order for engine and parts. Their claims now that they're bringing in this suit for conversion, et cetera, could have and should have been brought against Anola.
Well, let me ask, Mr. Palter, are you still pursuing claims against Anola or just against Yarger at this point?
Just against Yarger. Yarger was not a party to the first cause of action. Therefore, he was not in privity with that judgment. Therefore, res judicata does not apply. We're not seeking against Anola.
Okay, then I'll let Matty Hayes then make some comments on the statute of limitations.
Okay. Ms. Hayes?
Good morning, Your Honor. As to claims against Mr. Yarger, Mr. Yarger, as Mr. Palter mentioned, was not a party to any suit. His conversion claim began to run at the very latest in May of 2015 when that demand letter was sent to Mr. Yarger. Conversion is, as well as the Texas Theft Liability Act, are both 2-year statutes of limitations. 2 years are run for 2 years, which would mean that May 2017 would have been the expiration of that claim. Nothing prevented Convergence from filing a conversion cause of action against Mr. Yarger. He was not a party to that suit or to this suit. Therefore, we believe that
Ms. Hayes, in 2015, did Mr. Yarger have possession of the airplane parts?
Yes.
Okay, and he's had them since then?
Yes, Your Honor.
Okay, go ahead.
Which also brings me to my next point, that the discovery rule also doesn't apply because Convergence was well aware at that time, since they sent the demand letter, which their argument is that, by sending that letter, that triggered the 2-year statute of limitations, which continued to run. Therefore, nothing told. And therefore, their claims against Mr. Yarger are barred. As to the Convergence and Texas Theft Liability Act. As to Convergence's claim, breach of fiduciary duty claim, according to Convergence, the last day Yarger owed a fiduciary duty to the company was January of 2014. Breach of fiduciary duty is a 4-year statute of limitations. Therefore, it expired in January of 2018, which was well before this court signed the default judgment. Therefore, there was nothing preventing Convergence from filing suit against Mr. Yarger.
Okay. So when are you saying that the statute, the breach of fiduciary duty claim started? What day was the first day?
When it first started,
or when should they have brought the claim, or when should the statute of limitations run from?
Honestly, Your Honor, I've been going from the very last date that it possibly could have run, just to see if anything would have fallen within that statute.
And you're saying that's January 2014?
Yes, Your Honor.
Okay. And is there an argument as to the discovery rule for the fiduciary duty? Could they argue that it started on May of 2015 when that's when the letter was sent, correct?
Even if Your Honor, even if it was May 2015, it still would fall.
Outside of the 4 years.
Exactly. And it would not be told by the default judgment, as Mr. Yarger was not a party to the second suit or the first suit. And nothing prevented Convergence from filing suit against Mr. Yarger.
Mr. Palter, it seems like this is a pretty strong statute of limitations argument. Was there ever a summary judgment filed on this that I denied, or?
No, Your Honor, there was no summary judgment on this. I think there's two different claims. First claim is the fiduciary duty claim. And in all candor to the court, I think there's a very strong argument that fiduciary duty claim started on the date that he was terminated for cause as a fiduciary duty.
And that was
2014.
Okay.
The convergent claim for conversion of the parts, however, is a much more difficult problem, because they assert that there can only be one cause of action, or that there was not two separate breaches. And the problem we have is that because they filed a second lawsuit where they specifically secured a finding that they own the engine, that we assert that starts a different cause of action for conversion. They then used that judgment to go to Prime Turbine and say, look, we now have a default judgment. We own this engine. And Prime Turbine would not release it. So the problem we have is that by using the judicial system and without notifying us of that judgment, they've asserted a new claim which commenced on the date of the default judgment. We couldn't get the parts from Prime Turbine.
But the default judgment didn't affect Yarger, right? He wasn't involved in the default judgment, correct?
It did not involve him, but it did involve Prime Turbine. Onala was the one that was created, and the evidence will demonstrate that Onala is a single member entity owned solely by Yarger. Owned solely by Yarger.
I'm not sure I see your argument there, but all right, Ms. Hayes, did you want to say anything else?
Not at this time, Your Honor.
Okay. Do we want to just try this as a whole, or do you want to? I just don't see how you get past statute of limitations on this, but that's, I'm going to let you try your case, but I'm not sure how you get past statute of limitations on either of these claims, but as to Yarger, but I'm going to let you try it. I just hate to waste everyone's time.
Well, Your Honor, I would like to create the record associated with the efforts undertaken by Yarger subsequent to the second default judgment to use that judgment to prevent us to get access to the aircraft engine, which is the basis for the conversion claim.
But he had the aircraft parts and engines, as I understand it, since 2014 or before, correct?
But he
had them the whole time.
He had them at the whole time in his capacity as a director. And then he was terminated in his capacity as a director in January of 2014.
Well, that even with a 4-year statute of limitations from that point,
But the issue is, Judge, we had a judgment in the 2015 case that said we owned it, right? There shouldn't have been any dispute as to the title to those engines and parts at all. We didn't need to file a conversion case because we had a judgment by this court saying we own those engines and parts. It was only after the second default judgment came in and he said, look, they no longer own these engines and parts. We own them, right? So we didn't need to get a second cause of action because we had an order by this court declaring that we were the owners. We had a judgment to enforce. There's no limitation on the enforcement of the judgment.
Okay. I mean, I guess what makes sense to me, and maybe I'm again, you guys are much deeper into this, but kind of as an outsider, this isn't an order. This is a suggestion. Is why wouldn't you have Mr. Yarger turn over? You already have a judgment that you own these parts, correct?
And the engine.
And the engine. And Mr. Yarger hasn't turned them over. You're right. You could pursue post-judgment enforcement to try to get it back from Mr. Yarger. And ultimately, I assume that you would be able to get it back if it still exists. Couldn't you guys just reach an agreement that all of those get turned over to your client, Mr. Poulter, and then you guys non-suit this claim? Because I just don't see that you have any causes of action that still exist at this point against Mr. Yarger. That doesn't mean you shouldn't be able to get those if as I understand it, and again, I think you did an excellent job, both sides did an excellent job of arguing this. Your client owns these parts and they should be able to get these parts back from Mr. Yarger because you guys are, as I understand it, the record owner of these or the judgment owner of these. Mm-hmm. But I don't see how you have a cause of action against Mr. Yarger at this point based on statute of limitations. I mean, I just, that's what seems like should happen here.
And I understand the court's point. The practical problem is that Mr. Yarger has the hull associated with this, that he has tried every way he can to prevent us to get access. So yes, if there was no second lawsuit, that's exactly what we would have done. We would have enforced the judgment. We would have sold the parts to mitigate our loss. That's what would have happened. But by interfering with our ability to get the parts by filing this second lawsuit, now the parts themselves have diminished in value. And so
why didn't you start post-judgment activities back in 2014 when the original, is it 2014 when the original judgment was signed?
2016.
It's 2016.
I'm sorry, 2016 when the original judgment was signed. Why didn't you start?
The testimony will demonstrate that we could not get what are called the yellow tags for the parts, that Mr. Yarger had individually had to secure those yellow tags for the parts because we could not market those parts without the yellow tags. So we were attempting to secure those yellow tags, which is what was the delay.
Is that something you get from the FAA?
It's something that Mr. Yarger has to get from the FAA because he was the original person who was paid to secure these parts.
I mean, I guess what makes sense to me is, again, I'll do this trial so you can make a record and maybe I'm missing something, but I think the practical thing here would be, why don't we agree to the appointment of a receiver? The receiver goes, works with Mr. Yarger to get the yellow tags, and then you get possession of these, of this property. I mean, we can do a trial. I'm not trying to stop you from your right to a trial. I'm telling you what makes sense to me, but I'm happy to.
Would it make sense for us to talk in a separate room with our client to discuss those issues?
That's okay with me.
We've got Alan Robinson.
How do you guys want to do it? Do you want to be all of you in the room together, or each side go into their own room?
I think we can all be in the same room.
Yeah, I need to talk to my client private. I can talk to him by telephone. I can call him.
Whatever you prefer. I can set up a breakout room and
breakout room would be nice, I guess, just sending one of us to the breakout, or both of us, both sides.
So do you guys, both sides, want to be in the same breakout room or in separate breakout rooms, or do you want to talk to each other?
Why don't you put us in one breakout room together? We'll talk to our clients separately on the phone, and then we'll convene back in that breakout room and maybe give us till 11 o'clock.
Mr. Hayes, is that okay with you?
Yeah, that's a good idea.
So I'm going to put Alan R. from UK, Greg Eister, John Poulter, Maddie Hayes, Orville's iPad. Is that right? Orville's iPad, does he go into the room too?
That's Mr. Yarger, yes.
And Scott Hayes. Am I missing anybody?
That's it, Your Honor.
Okay. I'm going to open all rooms to allow you guys to go in and then come back to this room so you can leave your breakout room, come back to this room by 11 o'clock.
Okay. And Orville, I'll call you.